I've been teaching for about 2 years, so this presentation I realized after grading my latest memo is probably overly ambitious in terms of incorporating some of these exercises into the first year curriculum, but a lot of this presentation really has been a genesis of working on a summer course that's geared particularly for first year. It could be upper level students who cannot gain a paying job. So it's not, the course design really is to give them assignments that they typically would have as a summer associate or a summer law clerk. So I started coming up with these types of exercises, and really I'm interested in sort of this relationship between combining the theory with practice, the hard skills and the soft skills, to prepare students for the expectations of the audience wherever they find themselves. So my little tree frog certainly is adapting to its environment. I think one of the soft skills that's very important in the first year is teaching students adaptability. So, and I welcome your questions, comments, suggestions, observations. At the end, I'd love to discuss, get your thoughts on whether, in fact, many of these are overly ambitious. I posted to Twin sort of an outline of the 3 main environments I'm talking about. It will be the judicial conference room or judges' chambers, the law firm war room, conference room office, and the client's office. So those are the 3 settings I think I've been trying to work around to incorporate, again, very short, discrete assignments, sometimes just a simulation or discussion. So that's the background. We're going to talk a little bit about some typical assignments, again, explore the audience and their expectations, and I really want to focus on giving you some ideas that I've had for these assignments. And again, I don't think it's news to anyone how the landscape has changed. I think we can all concede that point. One interesting statistic is the most important criteria for mid-sized firms, and I just took mid-sized firms because it seemed good, it's in the middle, is fit. Now, what does fit mean? Is it personality? Is it culture? Is it adaptability? I think my theory is it's a combination of both. When I was on the recruiting committee at our firm, we used the Domino's pizza test. When it came down to brass tacks, grades versus writing samples, people being equal skill, it was, would you want to have pizza with this associate at midnight? Unfortunately, that's the inner secret of the recruiting committee I was on. It really is about personality, but that's not to say that we also didn't consider the delivery. We want the pizza to be delivered, we want it on time, we want it hot. It better be right the first time. We don't send the pizza back. So it's very much an adapt and overcome environment. That was in a large firm, and that was certainly in a judge's chambers. It better be right and delivered on time the first time. So, okay, how do we prepare our students for that in our curriculum? Obviously, success is a combination of these 2 hard and soft skills. I think the research and the studies about evaluations across the board in the legal environment is we want the substantive work product and we want these soft skills. Professional development, client relationships. Not an easy thing to teach. That's why I think practice makes perfect. So that's the goal of these assignments. What are some typical assignments that summer associates or law clerks may get? Of course, we have the memos, the traditional memo, maybe, maybe not. That's changing. There's people that are far more up to speed on the depth of the traditional memo than I, but certainly I can count on one hand the number of traditional memos I did in 6 or 7 years of practice. The modified memo is far more common. What's a modified memo? Well, a research memo. Find me the answer on this discrete issue. You may have facts, you may not have facts. Just find me the answer. An example. Research the enforceability of a jury waiver provision in a loan document in Florida. Fairly discrete issue. Is a jury waiver provision in Florida in a mortgage agreement enforceable? Write a 3-page memo. Bench memos, obviously, as you all are aware, vary from judge to judge. Type, style, again, know your audience. So how do we teach our students, considering that in this audience I have 20 different people who want 20 different things, perhaps. It's a very difficult position that we find ourselves in. Now, what are some other assignments, some discrete assignments? Just find a discrete research issue, maybe a page. Clearly reviewing documents is a big part of being a new associate. You're going to have discovery logs, privilege logs, motions to compel. Site checking briefs is, at certain firms, not a paralegal activity. It's a young junior associate. Can you do this? Test. And that's what students, I think, fail to realize. Every assignment that they get is a test, even if it's just their attention to detail. Letters, it could just be an enclosure letter. Please find enclosed documents, bait stamps, X through Y. Can they write that successfully without one change? And then there's a whole host of CLEs, presentations, 50-state, the infamous 50-state survey. So looking at those types of assignments, I am overwhelmed, and this is only my second year teaching. How do I do this? Obviously, I tell my students to know your audience. They have to take it upon themselves to research who they're working for, obviously. What does the boss want? The fundamentals of any work product for a judge, a client, or a firm have these core components. It's clear, it's correct, it's concise, and it's comprehensive. Again, that sounds overly simplified and very difficult to do, but those are the basic principles. Writing up the assignment, again, what is the expected format? Looking at what the boss, the partner, I tell my students, talk to the assistant. The assistant is your best friend. She or he will help you figure out what it is that partner X wants. So again, the soft skills. Do you have the confidence to ask for help? And again, some really typical things that I think throughout your course you can emphasize. And anything you turn in is not a draft. It better be the final work product, or pretty doggone close. So, some do's and don'ts. My favorite is don't scribble a Post-it note on a stack of cases, which I got from summer associates that says, here you go. That would be bad. Or judge. Surprisingly, sometimes some students don't know not to do that. Now, what are the hard skills? Obviously, the issue spotting, procedural and substantive skills that they're learning in their doctrinal courses, but also I think we can emphasize and further in our course. Can you find the answer? Can you research and get your arms around the issue? And it might just be reviewing the file and being the expert on the facts of the case. So those are sort of, I think for any environment, those basic principles apply. So what soft skills are we looking for? The can-do attitude. Give me a solution. Take a lot of notes. Ask appropriate questions. Again, realize everything is a test. And then panic is probably the one soft skill not to do. Keep your composure. And just avoid, I think one of the things that my colleagues and I talked about that summer associates tend to do is they avoid making a recommendation. Here's the law. I gotta go. Because I don't want to put myself out there and be wrong. That is the worst thing you can do for a judge or a partner, is not make the recommendation, not follow through. So again, we all know these soft skills for any assignment, and I'll post. This is posted on Twin as well. So I want to get to some very specific examples. Be prompt and responsive. Even in emails to the professor, students cannot communicate the appropriate tone or level of professionalism. Hey, Professor Haught, I got a question for you. That irks me to no end. And I have seen that more than on one occasion. Dear Barbara, I received your email regarding additional research. So the level of informality, I think, could be a cultural, could be a technological, could be a generational issue, but it's unacceptable in the legal environment, and I don't think our students realize that. So that's a challenge that I faced. I put Miller on your chair. No, dear, whoever. These are really simple things, honestly, that make sometimes more of a difference than not necessarily grasping a complex issue. So the judicial conference room. A student finds themselves as a junior law clerk or a summer law clerk to a judge. This exercise that I've come up with, and again, these are all outlined in this handout, and I apologize for not having copies, but this is really to expose law students to a scheduling conference, a status conference. Very typical assignment they would get as a junior associate. Go to the status conference. Don't screw up. Well, what does that mean? I didn't know what that meant. I didn't know how to act. I didn't know how to set a briefing schedule. So this assignment incorporated in our curriculum, the spring we have a federal memo. So I think you could take the opportunity to introduce this concept and let the students set the briefing schedule for their submissions. So most federal courts, as you know, have a standard Rule 26 report. It can be modified, break the students basically into 3 groups: a plaintiff's attorney, defense attorney, and a law clerk. 3 students per group. And they have to come up with a briefing schedule. They have to talk about the issues of the case. They're going to have the complaint, they're going to have the answer, and it's an opportunity to introduce this environment. How do you act in what goes on in these elusive status conferences? So again, I hope it's not overly ambitious, but I think it is a good introduction, particularly if your students are taking civil procedure. They should understand, although I don't know that Rule 16 is actually covered in most civil procedure classes, and I think it should be, but it's not as sexy as some of the other rules to talk about, because it's very perfunctory. That's what lawyers do. They work together to try to set the briefing schedule. A bench memo on pending discovery motions. Again, students, it might seem overly ambitious, but if you have 2 competing motions, the junior law clerk to the judge, their job, his or her job is to brief the judge on those pending motions and make a recommendation. These motions and briefs can be short, 2 to 3 pages, on any number of discrete discovery issues. I think students struggle with just summarizing information and looking at a rule and making an analysis and an oral recommendation. Giving them more opportunities in law school to practice what they're actually going to do, and then obviously talking about the theoretical import of whatever the topic or the issue is. So again, just some opportunities for them to work on maybe a different style of memo. If you have relationships with judges in your community, maybe you can have a judge come in, talk to the students about these requirements. So the war room, my least favorite assignment to give or have to do was the tag team writing of a brief. Basically, the senior associate partner might write the entire brief without one case in it, and then hand it to a junior associate and say, please find the law to support my theory, because I am correct. So it's working in the reverse. Find me a case that says X, so I can insert it into a brief. The analytical writing, researchability, obviously we're working on those skills. I think this is easily adaptable to at any point in the first year curriculum. Find me a case that says X, write a case illustration and email it back to me. Short, discreet, practice makes perfect. So again, I think it's relatively easy to do. My TAs grade these for me. It's good practice for them. And in an upper level course, this could work well particularly if the 3L is the senior associate in the hierarchy of the firm, and they're the writer, because being the writer of the brief is the most important thing. I don't bother myself with research. I am the drafter. So that sort of mentality is hard to deal with sometimes as a junior associate. So the junior associate has to perform the research and work with the senior associate to get the brief written. So they have to collaborate, which is a skill that law firms say students just don't have. They cannot collaborate. And I think law school in general lends itself to a hyper competitive, I'm not going to help you. And so you get in a firm, and certainly I'm sure you all experienced this. If you worked in a firm, I'm not going to help you. You do your own work. So I think it's a chance, maybe again, pie in the sky, to change the culture a little bit on our end. So the client's office. How do you keep your client's ducks in a row? Sometimes can be difficult as a junior associate, particularly to wrangle a difficult client. And oftentimes the partner or the senior associate might actually defer that. You communicate what we need, particularly from a document level. Get these documents from the client. Thanks much. Okay, how? Yes, but how? How do I do that? In the example that I have in the handout, basically is a client email update. You have a defense client and they just lost a motion to compel, must compel documents. The partner says, I need an email in 30 minutes to send to the client. So again, under time pressure, write an email summarizing this 2-page order granting the motion to compel and outline what documents are needed. So we have a 2-paragraph email. And I think you can easily incorporate that into an assignment that, again, the TAs could grade. We have a few minutes left. So some additional exercises. Calculating time. Reading a rule and calculating time. You could do that in 5 minutes in class. Shocking how many clerks and junior associates cannot calculate time or apply the mail rule. These are really important skills that you never get taught in law school, and it really does test their ability to read a rule and apply it. So that's an easy 5-minute exercise. Chart of claims and defenses, I think I try to incorporate this into the class just when they're working on their memos, but I think it really is an important assignment that you could adapt to a variety of different scenarios. Site checking, please site check this brief. I've used the twin cite station exercises. Has anyone else used those? Basically on twin there's this thing called cite station, and it has sample memos that the citations are all wrong. So you don't have to come up with a bad brief, although you could probably go down to the courthouse and get 10 of them. So I welcome your questions. I want to turn it over to Michelle, but thank you very much for your attention.